I am District Court Judge Kathy Delgado. Jury selection may be the most important function that a trial judge performs. An impartial jury that renders a verdict based only on the law and the evidence is the foundation of a fair trial and the essence of justice in America. However, trial judges commonly report that jury selection is one of the most stressful parts of their job. Although most citizens are willing to do their civic duty, a few are overtly impatient with the process. In addition, many potential jurors equivocate about their ability to follow the law or to be neutral. Further complicating matters is the fact that attorneys' efforts to identify biased jurors sometimes results in confusing the veneer, muddling the record, wasting time, or improperly soliciting commitments from jurors. It is a trial judge's obligation to manage this process in an efficient manner while simultaneously respecting the rights of both the litigants and the jurors. The goal of this video is to teach the fundamental concepts of voir dire so as to make the process less stressful for new trial judges. There are 5 reasons a juror may be excused from a veneer. First, to be qualified to serve, the juror must be a U.S. citizen who resides in the county, is at least 18 years of age, and can read, speak, and understand the English language, among other criteria listed in CRS 1371-105. Second, if jury service would constitute a hardship on the juror, then the juror should be excused. Hardship should be distinguished from an inconvenience. All jurors are inconvenienced by some degree by jury service. However, a hardship exists when the juror has other obligations which are so pressing that the juror would be preoccupied by those obligations and fail to give their complete attention to the evidence presented at trial. Third, if the juror has been exposed to pretrial publicity about the case and cannot set aside previously formed beliefs, then the juror should be excused. Please note that exposure to pretrial publicity alone is not enough to justify excusal. The critical issue is whether the juror can set aside previously formed beliefs and decide the case based on the evidence presented at trial. Fourth, if the juror is impliedly or expressly biased, then the parties may exercise and the court grants a challenge for cause. And fifth, the parties may exercise peremptory challenges to excuse a juror. The primary purpose of voir dire is to allow the attorneys an opportunity to discover the existence of any beliefs held by potential jurors that would interfere with the party's right to receive a fair trial and to explore how deeply those beliefs are held. Information about what jurors believe is obtained from written answers jurors provide on a questionnaire provided by the court or by oral answers provided in open court in response to the court or counsel's questions. Some potential jurors come into court with a bias against the defense or the prosecution because of previous life experiences or perceptions based on media representations of the judicial system. For example, some jurors have such faith in law enforcement agencies that they assume the defendant is guilty simply because charges were filed. Other jurors have had bad experiences with police or with the district attorney's office, and they are skeptical about these agencies and whether these agencies are genuinely seeking justice. Sometimes these beliefs are deeply held, and other times the belief is based merely on fleeting perceptions. Frequently, after some education about the basic principles of criminal law and the importance of neutrality, jurors make it clear that they are capable of being fair and impartial to both sides of the case. The court is obligated to teach the veneer about the basic principles of criminal law before the voir dire process begins. Rule 24 provides that the judge shall explain to prospective jurors in plain and clear language the grounds for challenge for cause, each juror's duty to volunteer information that would constitute a disqualification or give rise to a challenge for cause, the identities of the parties and their counsel, the nature of the case using applicable instructions if available, or alternatively, a joint statement of factual information intended to provide relevant context for the prospective jurors to respond to questions asked of them. Alternatively, at the request of counsel and in the discretion of the judge, counsel may present such information through brief, non-argumentative statements and general legal principles applicable to the case, including the presumption of innocence, burden of proof, definition of reasonable doubt, elements of charged offenses, and other matters that jurors will be required to consider in deciding the issues. Brief, non-argumentative opening statements by counsel delivered prior to counsel's voir dire are sometimes referred to as mini opening statements. It is permissible to share the basic facts of the case with the veneer. However, there are pros and cons to such mini opening statements. While this procedure frequently provides needed context to jurors, it can also give sometimes jurors a misimpression about the purpose of the attorney's questions. The court should ensure that potential jurors understand that the attorneys are not asking for an opinion about a likely future verdict, but rather are asking about the juror's willingness to follow the law as defined by the court. Although the right to a fair and impartial jury is based in the U.S. and Colorado constitutions, the right of the parties to engage in the process of questioning potential jurors is not of constitutional magnitude. It is based merely in statute and rule. CRS 1610-103 and Rule 24 are virtually identical in their language, and they define 11 circumstances in which a potential juror must be excused for cause. 10 of these circumstances focus on the juror being a witness to the crime or having some relationship to one or both of the parties, such as landlord or tenant, and employer and employee. In these 10 circumstances, the law presumes bias in the juror because such circumstances give the appearance of bias. Regardless of any assurances of impartiality by the juror, a challenge for cause must be granted to avoid the appearance of bias in these situations. However, paragraph J does not relate to the juror's relationship to the case, but refers instead to the existence of a state of mind in the juror evincing enmity or bias towards either side of the case. This is the only type of bias in which the juror's assurances of impartiality may overcome the presumption or appearance of bias. The focus of paragraph J is on expressed or actual bias. Paragraph J and Rule 24 are the sources of authority for counsel being allowed to question potential jurors. Notice that these labels are counterintuitive. It is implied or presumed bias that cannot be overcome, and it is expressed or actual bias that is capable of being overcome depending on how the juror answers the questions of the court and counsel. Uncovering expressed or actual bias is where most of the action is in voir dire. The trial court has broad but not absolute discretion to limit questioning by counsel in voir dire. What are the bounds of this discretion? It is likely an abuse of discretion to prevent counsel from questioning jurors about the ability of a potential juror to follow the basic principles of criminal law as defined by the court, including the presumption of innocence, the burden and standard of proof, culpable mental states, the elements of a charged offense, the right of a defendant to remain silent, and affirmative defenses. In addition, it is likely an abuse of discretion to prevent counsel from questioning jurors about the juror's willingness to determine the facts of the case based only on the evidence presented at the trial, including the juror's willingness to assess the witness credibility, including experts and law enforcement witnesses, to consider both direct and circumstantial evidence, and to follow instructions which limit the use of evidence. Further, it is likely an abuse of discretion to prevent counsel from questioning jurors about the juror's willingness to not base a verdict on sympathy, bias, or prejudice, including questions about race, ethnicity, nationality, or religion, gender or sexual orientation, a juror's likelihood of overly sympathizing with a victim of crime, and controversial topics prone to cause unfair prejudice, such as gun possession, drug use, sexual behavior, or affiliation with controversial groups such as gangs. However, it is within a trial court's discretion to prevent questions designed to test the juror's knowledge or ignorance of the law. Questions designed to educate the veneer about detailed and nuanced aspects of a particular law, questions designed to educate the veneer about a party's theory of the case for the purpose of identifying jurors most likely to adopt it, and questions designed to commit the juror to a verdict or a future course of conduct under a particular state of the evidence. These concepts are best explained with a simple example. The following example is based on a domestic violence charge of assault, where the defendant is male, the alleged victim is female, and the defense has endorsed self-defense. Imagine the following 4 questions posed by the defense attorney to a potential juror. The questions all relate to bias regarding the concept of self-defense, and they are listed in order from the most general to the most specific. Question number 1. Do you believe you can be a fair and impartial juror if chosen? It is worth noting that this is the most acceptable question imaginable. However, it is not very probative of actual bias. Question number 2. Do you believe all people have the right to defend themselves? This question is badly worded. It could be construed as testing the juror's knowledge of the law. If it is meant to ask whether the juror is capable of following the law of self-defense as defined by the court, then it should be so worded. In addition, this raises the issue of whether the attorney is required to completely and accurately define self-defense before asking this question. The answer usually depends on whether an objection is lodged. Attorneys may comment on the law, but only the court can define the law. The court may sustain the objection, or the court has discretion to read the self-defense instruction to the venire so as to help make the question well defined. This is my usual process. Further, there is a question regarding how detailed the attorney's question is meant to be. If the question is meant to identify only those jurors who are dedicated pacifists in all circumstances, then it should be so worded. If the question is meant to explore the jurors' opinions regarding the finer details of doctrines such as retreat to the wall, apparent necessity, or initial aggressor, then the court has discretion whether to allow such detailed questioning. The facts of the case may or may not warrant such questioning. Question number 3. Do you believe that under appropriate circumstances, it could be reasonably necessary for a man to use physical force to defend himself from a woman? This is an appropriate question. The law of self-defense makes no distinction based on gender. Many people are taught in childhood that a man should never lay hands on a woman. Thus, this question is designed to expose a form of bias that could prevent a fair trial. In addition, this question is well-formed because it speaks in generalities when it refers to appropriate circumstances, and it is consistent with the law by referring to that which is reasonably necessary. Question number 4. Do you believe it would be reasonable for a man to punch a woman with his fist if she slapped him first? This question is not appropriate because it relates neither to the juror's ability to follow the law nor to a bias on the juror's part. It simply asks the juror to comment on a specific factual scenario. If this scenario is similar to the allegations in the case, then it appears the attorney is attempting to determine whether the juror would be receptive to the attorney's theory of the case. The court is within its discretion to stop this line of questioning sua sponte and direct counsel to focus on identifying bias. The trial court must grant a challenge for cause if a prospective juror is unwilling or unable to accept the basic principles of criminal law and to render a fair and impartial verdict based on the evidence admitted at trial and the law as defined by the court. If the trial court has a genuine doubt about the juror's ability to be impartial under the circumstances of the case, the court should resolve the doubt by sustaining the challenge. Assurances of impartiality from the juror, while frequently probative, are not necessarily determinative. A juror may claim that they can be fair, but do so in a hesitant or unconvincing way. The trial court must formulate its judgment based on the juror's answers, the juror's demeanor, and the entire context of the voir dire. When ruling on a challenge for cause, the court should describe those aspects of the juror's demeanor that contradict or corroborate the juror's statements, so the record on appeal is complete and the basis of the trial court's ruling is clear. Challenges for cause should be exercised, sidebar, outside the hearing of the jurors. A trial judge needs to be aware that potential jurors sometimes have life experiences of a sensitive or embarrassing nature and may need to talk to the court outside the presence of other prospective jurors. A trial judge also needs to be aware that jurors sometimes say things that could taint the entire panel and jeopardize the integrity of the trial. It is common for the court to ask members of the venire to indicate whether they have personally been a victim of the type of crime charged in the case. It is appropriate and necessary for the court and counsel to follow up with any potential juror who so indicates. However, the juror's answers to these questions may need to occur outside the presence of the other jurors. If such a juror were to graphically describe the traumatic effects that victimization had on herself and her family, it may irreparably inflame the passions of other jurors, and a mistrial may be warranted. When a prospective juror makes a potentially prejudicial statement during voir dire, the trial court may issue a curative instruction, question prospective jurors about the impact of the statement, or declare a mistrial. The better practice, however, is to attempt to identify those jurors in need of individual voir dire before the prejudicial statement occurs. Individual voir dire can occur in the courtroom when the other jurors are on a break, or it can occur in chambers or the jury room while the other jurors remain seated in the courtroom. Regardless of the location, it must be on the record. A review of the jurors' written responses to the court's standard questionnaire or to a special questionnaire designed for the case at bar can frequently identify those jurors in need of individual voir dire. Because even the most efficient jury selection usually spans at least a few hours, restroom breaks, lunch breaks, and overnight breaks frequently occur during jury selection. This means the court needs to give the veneer certain admonitions about what behavior is allowed when outside of the courtroom. Before each break, the veneer should be instructed that jurors may not communicate with any third party about the trial, except to tell others that they are serving as a juror. Jurors must avoid media exposure about the case. Jurors may not do research about the law or the case, and jurors may not conduct any investigation about the case. The law grants each side of the case a certain number of peremptory challenges, depending on the seriousness of the charge, the number of alternate jurors to be used, and the number of co-defendants that may be on trial. Jurors may be excused for any reason of the attorney's choosing, except that excusals based on race and gender are not permitted. The court has discretion to grant additional peremptory challenges to either or both sides for good cause. The first peremptory challenge is exercised by the prosecution, and then the parties alternate in their challenges. Peremptory challenges must be exercised on the presumptive jury, which is usually defined at the jurors seated in the jury box. Peremptory challenges may not be exercised on replacement jurors. If an attorney waives the exercise of further peremptory challenges as to the presumptive jury, the attorney may thereafter only exercise subsequent peremptory challenges on new jurors entering the jury box. Peremptory challenges may be conducted in open court in the presence of the juror without explanation by counsel. The Equal Protection Clause of the 14th Amendment prohibits racial and gender discrimination in the selection of a jury, regardless of whether the discrimination occurs by the prosecution or the defense. Thus, peremptory challenges must be exercised in accord with Batson v. Kentucky. If a litigant suspects that his or her opponent has exercised a peremptory challenge to purposefully discriminate against a juror on the account of the juror's race or gender, that litigant may raise a Batson challenge to the excusal of that juror. The juror should be retained by the court until the court has ruled on the challenge, and the Batson challenge should occur outside the hearing of the jurors. Batson provides that the court must conduct a three-step analysis in ruling on the challenge. In the first step, the challenging party must make a prima facie showing that the peremptory strike was based on the prospective juror's race or gender. The race or gender of the juror stricken need not be the same as the race or gender of the defendant. A pattern of strikes is not essential to such a showing as long as the totality of the circumstances raises an inference of racial or gender discrimination. In the second step, the burden of production then shifts to the striking party to come forward with a race-neutral explanation for the strike. Examples of legitimate, non-discriminatory reasons for a peremptory strike include residual doubt about actual bias, the juror's out-of-court obligations, or even the lack of ties to the community. Although the striking party must do more than simply assert good faith or deny a discriminatory intent, the standard to be met is not high. The explanation need not be persuasive or even plausible as long as it does not deny equal protection. In the third step, if a race-neutral reason for the strike is provided, then the challenging party is given an opportunity to rebut the race-neutral explanation, and the court must then decide whether the race-neutral reason is a pretext. The court must rule on the ultimate issue of whether the challenging party has proven by a preponderance of the evidence that the peremptory challenge was based in purposeful discrimination. The court's determination should be based on the evaluation of the striking party's credibility and the plausibility of their race-neutral explanation. If the court is convinced the explanation is pretextual, then the Batson challenge must be upheld, and the juror remains on the jury. Trial judges need not be stressed out during jury selection. Although managing a courtroom full of prospective jurors is a large task, the judge's focus should be on quality rather than speed. Trial judges should take pride whenever a fair and impartial jury is sworn in. Justice is worth the wait.